Kari Green was fatally injured when a Kootenai Heart Clinics delivery van stopped, made a left turn at an intersection, and struck her. Just months before the trial, Kootenai admitted liability for the incident. The only remaining issue for trial is the question of damages, specifically when Miss Green lost consciousness and whether she experienced pain and suffering before her passing. Kootenai contends that Miss Green lost consciousness almost immediately after the collision, resulting in minimal suffering. In contrast, Joseph Green, Miss Green's husband and personal representative, argues that she remained conscious throughout the traumatic sequence, being struck, run over, crushed, and transported to hospital. He maintains that she endured significant pain and suffering before passing shortly after arriving at the hospital. Mr. Green, representing his deceased wife, sued Kootenai Heart Clinics. The trial issues at hand are the delay in Kootenai's expert disclosure. In 2020, Mr. Green asked Kootenai to identify its expert witnesses and their opinions. Kootenai refused, saying they'd disclose them according to the court's schedule. In March of 2022, just 3 months before the discovery deadline, Kootenai revealed its expert, Dr. Chris Heller, who claimed Kari Green lost consciousness immediately and did not suffer. Kootenai did not disclose the basis for Dr. Heller's opinions or the documents he reviewed. His full opinions were not revealed until his October 2022 deposition, well after the deadlines. The plaintiff's late witnesses. Mr. Green disclosed Annika Greer, an eyewitness, just before the original August 2022 trial. She said Kari Green was conscious and moaning after the crash, contradicting Dr. Heller. Mr. Green also revealed 2 rebuttal experts close to trial, Dr. Bauer and Dr. Nara. Bauer would testify Kari was conscious, and Dr. Nara would confirm the autopsy findings. The trial was continued to November to allow time for depositions. Dr. Heller's changing theories. In his October deposition, Dr. Heller introduced 2 new theories: that Kari lost consciousness due to lateral whiplash and that her brainstem was severed on impact. These theories had not been previously disclosed. The plaintiffs attempt to rebut new theories. To refute Dr. Heller's new claims, Mr. Green tried to add 2 new rebuttal experts, Dr. Cantu and Dr. Josephson. In the end, the trial court ruled to exclude Dr. Cantu and Josephson, and it limited Dr. Nara's testimony. The court found Mr. Green's late disclosures to be willful and prejudicial to the defense, especially since trial was about to begin. Mr. Green has requested discretionary review of the trial court's ruling. The appellate court has agreed to hear it. Let's take a look.
Thank you, Your Honor. George Arend for the Green family. I'd like to reserve 6 of my 15 minutes for rebuttal, if I may.
Thank you.
May it please the court. On behalf of the Green family, we're asking the court to reverse the exclusion of their rebuttal experts and remand this case for trial. There's no dispute as to what the controlling authority is in this case. It's the Washington Supreme Court's decisions in Jones and Burnett. I think that's agreed. There really isn't any dispute as to the animating principle that undergirds these decisions and I think drives the result that this court is obligated to reach in this case. And that is, we favor resolving cases on the merits rather than on procedural grounds. Another way of saying that is we place the interest in an accurate and just result over case management concerns. This results in a presumption of the admissibility of evidence in any case, subject only to a narrow exception. I don't think there's any disagreement as to what that exception is, although when it comes to talking about what some of the requirements of that exception are, there is a little bit of disagreement. That narrow exception allows the exclusion of a witness if 4 requirements are satisfied. 4 requirements. The first requirement is there has to be a willful violation of a court rule or a court order. Willful violation is distinguished in these cases from a reasonable excuse for the timing or manner of disclosure of evidence or a particular witness. The second requirement, there has to be substantial prejudice, and not just any kind of prejudice. All evidence that is relevant is going to be prejudicial to somebody's case. All evidence that is admissible is going to have to be addressed by both sides in some fashion or another. But the prejudice that we're talking about here that would justify the extreme remedy of excluding a witness is substantial prejudice in the ability to prepare for trial. And there's a corollary to this requirement that's very important. It comes to the fore in this case, and that is there is an obligation on the part of the opposing party to mitigate their prejudice and not self-create prejudice. The third requirement, no lesser remedy than exclusion will suffice to ameliorate the prejudice, the substantial prejudice to the opposing party's ability to prepare for trial. And then the fourth and final requirement is there have to be specific findings in the record to support each of those other three requirements. Now, in this case, the Superior Court erred right out of the gate by not having sufficient findings. The commissioner who granted, or
Judge Clark or Judge Poland?
Judge Poland, the only orders that are before the court, the only ones we've appealed are Judge Poland's orders, because those involved a different state of affairs that existed than when Judge Clark issued his ruling. We've abided by Judge Clark's ruling, and so it's the subsequent rulings by Judge Poland, and there are two of them. First, the Judge Poland, and it isn't, you know, we can talk about all of these elements. I want to focus on prejudice, but I can talk about willful violation right out of the gate. We got new opinions on October 4th of 2022, I guess it is now. And within days after getting those new opinions, by deposing an expert that had been designated by the defense, the respondents in this case, we disclosed rebuttal testimony. Now, recognizing that the case scheduling order deadlines had passed and that Judge Clark's prior order had provided that there wouldn't be any new discovery or disclosures, we filed a motion to supplement our disclosures, for leave to supplement. And in response, the defense, the respondents, filed a motion to strike. Judge Poland granted the motion to strike, denied the motion to supplement, largely in reliance on Judge Clark's order, even though the circumstances had completely changed. Judge Clark had also ordered a deposition of this expert from the defense side. We got these new opinions. Those circumstances weren't in front of Judge Clark. That was Judge Poland's responsibility to decide what to do under those circumstances. And then when we filed the immediate motion for discretionary review, the parties subsequently entered in. So there's no willful violation. I want to just emphasize that. No willful violation. We're seeking leave of the court to modify the deadlines for disclosure to accommodate the late receipt of opinions, new opinions from the defense expert.
Let me ask you this. In your discovery request, did you ask that they provide the a summary of the evidence to be provided by their experts?
Yes, a complete statement of complete opinions and the basis for all of those opinions, following the language, you know, everything that CR 26 allows us to request of an opposing testifying expert.
And did they respond to that?
Yeah, they said, we'll disclose it in accordance with the case scheduling order. And so then we get a disclosure that says, Ms. Green lost consciousness as a result of impact with the vehicle. And it was bare bones, didn't disclose the basis for those opinions. I asked for supplementation before the original trial date. I got in response, we're not going to supplement, we're not going to answer. We acknowledge we didn't answer the interrogatories. We also had a request for production asking for the expert's complete file in the case too, which they had deferred answering. I asked for supplementation of that. And they said, you already have everything. That was false, because when we deposed Dr. Heller, we didn't have his opinions that, well, actually, even though his disclosure said Ms. Green lost consciousness as a result of impact with the vehicle, he says, well, she didn't impact the vehicle when he's deposed, that she lost consciousness as a result of something he called lateral whiplash. All right, it's just a made-up term, and that's now been withdrawn following our designation of rebuttal experts, showing how some of this, the extent to which some of it was unfounded. We also, he said that Ms. Green's pons, a portion of her brainstem, was transected when her head was run over by the vehicle. Sorry, that's graphic, but it's just the way it happened. And that was completely new. Nothing in the prior disclosure, or certainly in the non-answer to our discovery request, about that opinion. And then the basis for the opinions, he's relying on a 20-second clip of an NFL football game. That hadn't been disclosed either.
So let me ask you, and maybe I'm incorrect, we have a lot of cases, but Judge Poland, I thought, had said, well, don't you have a duty then to move to, what am I thinking? Sorry, my brain's muddled now. Duty
Motion to
compel. Pardon?
Motion to compel.
Yes, motion to compel. There we go. Didn't Judge Poland say, well, not, you know, they didn't respond. You have a duty to compel, file a motion to compel. What's your response to that?
Yeah, Magana versus Hyundai says absolutely not. Those discovery requests are self-executing. We have a right to rely on everything being produced in response to those discovery requests. Going back to FISONs, the obligation to comply with the discovery rules is never contingent upon the other party making you do it, because then otherwise it's a free-for-all. We're going to violate the rules until somebody...
Isn't there also just a concept of collegiality where you pick up the phone and you say, you know, your disclosures are not very good here. Can't you supplement and actually tell me what your expert reviewed? Can't you tell me what your expert is actually going to say? Can't you actually follow the rules and do what you need to do? Isn't there that aspect of the practice of law? I know that you're citing the case law that says you don't need to do that, but isn't that how we actually get these cases litigated and into court in a fashion so that discoveries are all on the table before we start trial?
Absolutely, and that's exactly what we did in this case. CP 621, a letter, please supplement right before trial. CP 623, a follow-up email, please supplement. CP 625, we readmit we didn't answer it and we're not going to supplement. That's their response. And so then we depose Dr. Heller after they resist a motion to either exclude him, and then we moved to exclude him because they weren't supplementing. And Judge Clark said, well, I'm not going to exclude him, but I'll allow his deposition. So that's when we finally got it. So if it's in terms of collegiality, absolutely that's the way it's supposed to work. It's not supposed to be this, let's try and get away with everything we can until somebody catches us trying to hide the ball. I seem that my time has expired, and I just want to conclude with one final thing. You know, if the easiest way for this court to resolve this case is to find no prejudice, I don't think there's any willful violation here, but there's no prejudice because when we filed our motion for discretionary review, the parties agreed to an indefinite continuance of trial. There can be no prejudice, ipso facto, under those circumstances. And so this court, despite the inadequate findings by Judge Pullen, I think this court is obligated to reverse and reinstate these expert witnesses that have been excluded. Thank you.
May it please the court, Matt Daly appearing for the defendants, Kootenai Medical Center and Kootenai Heart Clinics, LLC, which I'll collectively refer to as Kootenai. Kootenai respectfully asks your honors to affirm the trial court's order striking untimely witnesses. Before I jump into it, I want to make a couple brief comments about the colloquy with respect to Dr. Heller. The first is at page 84 of the verbatim report of proceedings. Counsel acknowledged that they made a strategic decision to not seek Dr. Heller's deposition. The second is counsel's assertion that
Did they have an obligation to seek the deposition?
They did not, Your Honor, but to later subsequently assert that they were prejudiced by their own strategic decision is improper.
Well, so let me ask you this then. They sent out interrogatories asking for the summary of all this. Didn't you have an obligation to answer that?
We did, Your Honor, and I respectfully ask the court to go back and look at the record.
So
counsel's
provided counsel with the theories that Dr. Heller was going to address this loss of consciousness and the brainstem. That was all provided to counsel in the discovery response that you sent.
So the only item that was not disclosed were the documents that Dr. Heller reviewed. That was provided upon counsel's request. That's in the record. Importantly, the documents Dr. Heller reviewed were the autopsy and the police reports at issue.
But you provided a summary of his theory, correct?
I did, Your Honor, and it is admittedly not extensive because Dr. Heller's opinions were quite narrow. It was that she suffered a loss of consciousness as a result of the initial impact. Counsel is trying to narrowly define that in a way that serves himself, but that's not actually what it says.
So this theory of whiplash, that was disclosed?
That was not, Your Honor.
Don't you have an obligation to disclose that?
Potentially, but that is more a basis for an opinion than
you have an obligation to disclose it.
It should have been disclosed, Your Honor.
Okay.
However, as we stand today, Judge Clark made a finding at page 166 of the record that there was no discovery violation with respect to Dr. Heller. I can find that there was no discovery violation. That order entered the 30th of September has not been appealed. And that finding of the absence of discovery violation is now a verity on appeal. This entire appeal is predicated on a collateral attack of the September 30 order, which was never appealed. Now, I think that while I don't want to belabor the facts, the procedural facts in this case are extremely important. This trial actually began on August the 10th of 2022. It was paused due to a lesser sanction under Burnett and Jones for the plaintiff's failure to timely designate an expert named Bauer. We have since August 10th of 2022 been in this weird twilight limbo where the case was paused as a result of that lesser sanction. And everything that has happened since then has been in this limbo twilight period where the plaintiff has attempted to capitalize on that lesser sanction in order to add new witnesses and to reshape the case. And ultimately, what this boils down to is two different philosophies on Burnett and Jones. The plaintiffs would have your honors look solely at a point in time, October 28th and November 4th of 2022. And the plaintiff would have your honors solely focus on whether there is adequate time to conduct depositions. But that's not the sole reason that we have discovery sanctions. That's not the sole reason that we have Burnett and Jones. The Burton case clearly holds and has held for many years that one of the touch marks of discovery sanctions and Burnett and Jones is that no party be permitted to benefit from a lesser sanction and their own discovery violation. And that's where we stand today. The plaintiffs are trying to collaterally attack an unappealed order, and they're trying to add new witnesses during this limbo twilight that we've been in since August of 2022.
Counsel, couldn't the limbo twilight have been resolved if the judge at the end had said, you know what, I'm going to go through these Burnett factors. I find they're not willful. I'm going to allow just a little bit more discovery. We're going to put this into the following year, 2023, and we're going to get this done so that all parties can have their evidence presented to the jury as they want.
It could have, Your Honor, but that's not the circumstances we find ourselves in. The addition of Dr. Josephson, Dr. Cantu, and the effort to expand Dr. Nara's testimony were willful violations of Judge Clark's September 30 order. Judge Clark specifically addressed this prospect of what would happen after the deposition of Dr. Josephson at pages 172 and 173 of the record. And
let me get this straight, though. You admit that you should have given them more information about Dr. Heller's testimony or his proposed testimony when they do depose him. After you didn't disclose this information, they find out this new information, and now they want to provide their own experts to refute the information they learned newly during this deposition, which is the only place they were able to obtain this information. Is that correct?
It's somewhat correct, Your Honor, but I think respectfully, counsel's trying to draw too fine a distinction between an expert's opinion and the specific base for it. Dr. Heller's opinion was that Kari Green lost consciousness as a result of the initial impact with the vehicle, thereafter suffered a traumatic brain injury, which is documented in the autopsy report. The autopsy concludes that she had a severed brainstem. And the mechanism whereby Dr. Heller bases that opinion is this idea of lateral whiplash. It's not a new opinion. It's him fleshing out his opinion that she lost consciousness.
But wouldn't counsel then, once he found out that this severed brainstem and the transected pons is a pretty pivotal moment on whether someone has consciousness or not at the time of death, wouldn't they be able to say, hey, where is the person that did the autopsy? And it's the person that did the autopsy that thinks, we transected it during the autopsy, not from at the time. And you're looking at me strangely. is it because the person that did the autopsy, don't you think the plaintiffs have the right to bring that person into trial to testify?
Person's not designated in any way, shape, or form. Dr. Edwards performed this autopsy. He retired, and the plaintiffs designated Dr. Nara for the sole purpose of authenticating the autopsy report. I'll also note, to Your Honor, there is no indication in the autopsy report at all that there was any reason to suspect that the brainstem was severed during the autopsy. All of this is an after the fact characterization by the plaintiff. If we were talking about a fact witness.
Don't you need a trier of fact to say when this occurred, and evidence that a trier of fact can listen to find out when this occurred, transected brainstem occurred?
Absolutely, we do. And the only reason this case wasn't tried on the merits was because of that initial delay, which was entered as a lesser sanction under Burnett and Jones.
And
now,
this is saying the initial delay from the day of trial of August 10th?
Correct, Your Honor.
Okay.
Now, with respect to Your Honor's question, there is an important issue to bear in mind. And that is that the parties submitted a joint trial management report on July 14th of 2022. In that joint trial management report, whether Mrs. Green suffered any period of conscious pain and suffering is a clear statement that's disputed in the case. At that point in time, however, Dr. Josephson wasn't designated as a witness, Dr. Cantu wasn't designated as a witness, Dr. Nara wasn't designated as a witness.
And Dr. Keller had not been deposed yet.
That's correct. And in fact, Annika Green is a witness. But establishing damages is a prima facie element of the plaintiff's claim. One of the bases that Your Honors could affirm the trial court on, in addition to this entire appeal being an impermissible collateral attack on the September 30 order, is the fact that establishing a prima facie claim, element of your own claim, is never proper rebuttal. That's Hornbook law. It's a setup in the Washington Practice Series. And so the plaintiff is asserting that they should be entitled to present rebuttal testimony in order to establish an element of their claim.
They had a witness, didn't they?
No, Your Honor.
A fact witness who was going to testify that she held this person in her hands?
Not until August the 3rd. At the time that the joint trial management report was entered, none of these people were designated. And even if the defendant had put on no evidence whatsoever, called no witnesses whatsoever, it was incumbent upon the plaintiff to prove their damages, including the existence of conscious pain and suffering. And so the assertion that we didn't know we had to prove our claim for damages until October, and therefore all this should be permitted by rebuttal, is simply contrary to law.
Mr. Daly, do you have a list of what you think actions of plaintiffs were willful violations that were the Burnett factors?
Yes, Your Honor. So the first is the failure to designate timely the Dr. Josephson. That Judge Clark ruled on that on September 23rd and entered an order to that effect on September 30. Judge Clark made clear in his September 30 order that the lesser sanction was entered solely for the purpose of affording the defendants time to depose Dr. Bauer. Notably, Judge Clark refused to permit me to take an additional deposition of Annika Greer during that period, making clear that the only reason this trial was continued was to depose Dr. Bauer. Now, contrary to the plaintiff's assertion, and Your Honors can go back and look at the transcript, Judge Clark did not order a deposition of Dr. Heller. Judge Clark specifically said he was doing it as an accommodation, that there was no prejudice, there was time, and it afforded the plaintiff the opportunity to prepare for cross-examination, to confer with anyone that they spoke, but that no new witnesses would be permitted. The September 30 order is crystal clear that no witness who was not designated before the 10th of August would be permitted to testify in this trial.
We're running out of time here, and I have some questions that I want to ask you, but one
Please.
of them would be what possible lesser sanctions did Judge Poland consider before precluding these rebuttal witnesses?
Judge Poland specifically considered whether a further continuance would be appropriate, and Her Honor noted that under the circumstances of this case, where it was already continued as a lesser sanction, where we were on the eve of the resumption of trial, and where the plaintiff was proposing, material additions to the case, not simple fact witnesses, that forcing Kootenai to undergo the additional delay and additional expense of adding 3 new experts during this limbo twilight period was unduly prejudicial. And that,
So I guess that takes me to the next question, which is what prejudice did Kootenai claim from allowing these additional witnesses?
that the case was fully framed, that Kootenai had prepared its case based upon the witnesses designated by the plaintiff in the joint trial management report, that it had already been required to suffer an additional delay and continuance, and that now the plaintiff was proposing it again. And ultimately, this goes to the fundamental difference in philosophy between these two positions with respect to the Burnett rule.
How would adding these witnesses prejudice Kootenai's ability to prepare for trial?
It would have required a further delay. It would have required, because they were proposing 3 new experts 4 days before the resumption of trial. It would have required additional depositions. It likely would have required additional witnesses by the defense to respond to these prima facie elements of the plaintiff's claim. Recall that these are about establishing the plaintiff's claim for damages. These aren't tangential issues, and the case was fully framed, and the defense can only respond to what the plaintiff proffers.
I think Judge Lawrenceberry has a question.
Yes, I'm back. Yep. About a minute ago, when the question was asked, what sanctions did Judge Poland consider? You answered a continuance. In my view, a continuance isn't a sanction. It's kind of a what happens if you allow further discovery. Did Judge Poland consider lesser sanctions such as a monetary penalty?
I don't believe so, Your Honor. The only statement the judge made on the record was a continuance. Now, under the Burnett and Jones cases, however, a continuance is deemed to be a sanction for untimely discovery. And now the situation that I think is critical for the court to bear in mind is that we were already under a Burnett and Jones continuance. The plaintiffs are proposing a rule with no limiting principle.
But Judge Poland isn't bound by Judge Clark's decision, correct? Especially when new information comes up as a result of subsequent depositions.
Of course, Your Honor is not judicially bound by it, but
and she needs to make her own Burnett analysis based on the new information before her, correct?
Correct, and she did on the record. The verbatim report of proceedings makes that clear, and what Her Honor considered, as is required by the cases of Marriage of Price and True Blue versus Marcel, is the totality of the circumstances, including the existence of a prior sanction. And what Judge Poland concluded correctly on this record and under these facts is that continuance after continuance after continuance to allow a plaintiff or any party to reshape the case on the eve of trial after a prior lesser sanction is unduly prejudicial, limits the court's ability to manage its docket, and does not further resolution of the case on the merits. Again, the defense can only respond to what the plaintiff puts forward, and the plaintiff is trying to bolster and establish prima facie elements. So that's not rebuttal.
Let me ask you a question, and I know you're out of time. We're going to wrap up here, but Mr. Aaron says at this point there's no prejudice because discretionary review's been granted, the trial has been stayed. There is de facto no prejudice. What is your response to that?
Time does not heal all ills. That is the fundamental dispute in this case, and it is two different philosophies of Burnett and Jones.
But we're not here to punish.
No, but we're also not here to prejudice the defendant by continuance after continuance. The Burnett and Jones require the court to look at the whole facts and circumstances of this case. And every judicial rule has to have a limiting principle. And if the rule that the plaintiffs proffer were adopted, what we would find is that time would always heal all ills. And that any time there was a Wheatfield witness, a continuance would be imposed. And then it would make room for another Wheatfield witness and another continuance. And that's precisely what the plaintiffs are asking Your Honor to do in this case. It's the fact that we were already under a Burnett and Jones continuance cannot be overstated in its importance. At some point, orders need to mean something. At some point, the case needs to be framed. At some point, the defendant needs to know what it's responding to. And when you have continuance after continuance after continuance, prejudice is manifest. And Judge Poland correctly found that.
Okay.
And Her Honor,
to wrap up because we're well beyond our time here.
so I want to conclude by noting that this case does give Your Honors multiple different bases upon which you could affirm the trial court. And we have, the goal of resolving cases on their narrowest grounds. Your Honors can resolve this case as an impermissible collateral attack on the September 30 order. Your Honors could decide this case on the basis that establishing a prima facie element of your claim is never proper rebuttal. But Your Honors also could, and I think should, take this opportunity to clarify that Burnett is not without a limiting principle. Burnett requires the court to look at the full history of the case, including a history of prior sanctions, and to confirm, as Judge Clark noted, that Burnett is properly used as a shield against rigid application of rules, never as a sword to allow a party to reshape their case after trial has begun, after a continuance has been imposed. We cannot have rules that require parties to respond to shifting theories. This appeal is not about resolving cases on the merits or not. This appeal is about the plaintiffs already being afforded a Burnett continuance for the untimely designation of Dr. Bauer, and then attempting to use that to add 3 more.
I appreciate it.
Let me just briefly ask, are there any questions about the Carson
time.
fine element?
I'm sorry.
I'm just saying you're 5 minutes over your time, but I guess if there are other questions, that is a good point to make. Any other questions?
Not about Carson versus Fine.
Thank you.
Thank you, Your Honor.
May I ask how much time I have remaining?
You have 5 minutes, 22 seconds, but we did allow the other side to go over a little bit. And if we do have questions, we'll use that time once we get past your 5 minutes.
All right, thank you. There is a fundamental disagreement over what Jones and Burnett means. And when counsel for Kootenai comes up and says, we need limiting principles, Jones and Burnett have already given you limiting principles. It's the 4 elements that we don't disagree about. You've got to have a willful violation. You've got to have substantial prejudice in the ability to prepare for trial. You've got to have an absence of any other remedy that would ameliorate that prejudice. And you have to have specific findings. Those are the limiting principle. If those requirements are not satisfied, you don't adopt another principle and say, oh, well, we had 1 continuance, therefore Jones doesn't apply, or we're not going to apply it in the same way. Jones and Burnett don't permit that. But let's talk about the Jones and Burnett continuance that preceded the untimely disclosure of Dr. Heller's opinions and the request to supplement our disclosure of expert witnesses. We weren't aggrieved by that, so we couldn't appeal, because by the time we were, the continuance was granted, there was no right to discretionary review as a matter of right. There was no right to an appeal at that juncture. There was nothing we could have done. We've corrected the record, starting on page 12 of our reply brief, to talk about this. Bauer had been a witness from the beginning. The defendants, after the discovery cutoff, after blaming the decedent for her own death, for getting run over herself, as well as a host of other parties, decided finally to admit liability and completely retooled their case. Bauer had been in the case for a long time as a witness to rebut their accident constructionists who were talking about how the head of the decedent hit the hood of the vehicle. That's the impact with the vehicle that's referenced in the scarce disclosure on CP 618-619 of Dr. Heller's opinions. Dr. Bauer was not a new witness. It just became apparent that even though they admitted liability, they were going to try and sneak in that causation testimony through. Yes, I'm sorry, I didn't see that, Your Honor.
That's fine. That's why I raised my hand, because you really can't see me trying to ask a question. Mr. Aaron, what kind of a lesser sanction should the trial court have considered rather than excluding your witnesses?
So there is none in this case, because there was no violation, there was no willful violation of a court order by the plaintiffs. And so you don't even get to the lesser sanction. I mean, conceivably, there's a host of things besides a continuance, monetary sanction. I don't know what the universe of possibilities might be. I do know that a continuance was the only one that was considered or requested in this case. And then eventually a continuance was agreed to by all parties. Does that answer your question?
Yes, it does. I'm having a difficult time understanding why a continuance is a sanction. I think sometimes that's just what happens if you have to allow further discovery. But if we were to agree that there was some willfulness involved, I think that Kootenai makes a strong argument that some of these witnesses actually were your case-in-chief witnesses, or should have been. So there is something that might sustain the trial court's finding of willfulness to some extent, not to a broad extent, but maybe to a narrow extent. And I'm just wondering just how seriously the trial court should have considered a monetary sanction.
Yeah, I don't suggest none, because there is no willful violation. The other witnesses that you're talking about aren't the subject of this rebuttal testimony, and there was no attempt to use this rebuttal testimony to satisfy our initial burden of proof. We had healthcare witnesses and first responders who were all going to testify about the circumstances of the accident and the consciousness of the decedent. Annika Greer only came up as a witness because the parties had agreed to put in their witness or their pretrial report a video that was taken by the police, and she was on it and talking on that video, and it made sense to avoid hearsay objections and bring her in person. But Mrs. Greer isn't the subject of this appeal. The meeting of the plaintiff's burden of proof isn't the subject of this review, I should say. And we had plenty of evidence to meet it. We just wanted to rebut lateral whiplash, transected pons, and the NFL videos that were previously undisclosed.
How do you respond to counsel's argument that this is basically an end-run collateral attack against Judge Clark's decision?
So thank you for that. I do want to address that. So Judge Clark on 930 says there wasn't a discovery violation justifying exclusion of Dr. Heller. I disagree with that decision, but we're not really aggrieved. We could still appeal that issue because that wasn't accepted for discretionary review, although the scope of review could conceivably include that under Rep 2.4. However, when he said no discovery violation justifying exclusion as of 930, he also said you have leave to depose Dr. Heller. At the time he made that ruling, nobody knew about lateral whiplash. Nobody knew about transected pons. Nobody knew about the NFL video on which Dr. Heller purported to rely. All those things surfaced at his deposition on October 4th. And so it's in light of that new information that renders that prior order inapplicable, because Judge Clark didn't have the information that we all have now, the information that Judge Poland had when she should have granted the motion to supplement to respond to these new, previously undisclosed opinions. I see that my time has expired. I would like to have 1 minute if I may.
You may.
Thank you, Your Honor. I was looking at the wrong place. I'm sorry. This discovery request was very clear. Please provide the following related to all experts: identification, all opinions, basis for each opinion, including but not limited to identification of facts, witnesses, and documents relied upon by each expert for each opinion. And they say, well, we'll disclose it in accordance with the case scheduling order. Here's what they disclosed. CP 971, although it appears multiple places. Dr. Heller will provide testimony regarding Mrs. Green's injuries and level of consciousness resulting from the vehicle impact. Nothing about the subject that prompted us to disclose this rebuttal testimony. If we're going to resolve cases on the merits, plaintiffs, the Green family, should be allowed to present that rebuttal testimony to the jury. Thank you.
Following these arguments, the court found the trial court erred by finding Mr. Green's discovery violation was willful or deliberate. The trial court's order for witness exclusion was reversed. Please let me know what you think about this case in the comments below. And if you like this video, please hit subscribe for new arguments every week.